Law 529, Law of Evidence 1, the topic of similar facts evidence. Assalamualaikum warahmatullahi wabarakatuh. In this video, I am going to discuss with you the relevancy of evidence which falls under similar facts evidence. In this discussion, we are going to look at what is actually similar facts evidence. We are also going to look at the relevancy of similar facts evidence under the common law and the relevancy and admissibility of similar facts evidence under the Evidence Act 1950. Okay, to start off the discussion, what is actually similar facts evidence? Now, when we talk about similar facts evidence, a similar facts evidence or SFE is basically where the circumstances or evidence in which the accused's previous misconducts other than which give rise to the offence charge are made admissible in court because of their similarity to the current offence. What we are talking about here is that you have an accused person has been committing an offence with similar modus operandi. The accused person may have committed the offence in previous years to a different victim at a different time, and he is currently committing the same offence to the current victim in the current facts and issue. Now, what we are talking about, so when we are talking about similar facts evidence or SFE, as a general rule, the previous misconduct of the accused person, which is not related to the current charge, is basically not relevant and not admissible to be tendered as evidence in the court to prove the current charge. Why is this so? The rationale for disallowing similar facts evidence basically because there exists a presumption in law where a person is supposed to be innocent until proven guilty. What happened here is that if you allow for the previous misconduct of the accused person to be tendered as evidence in the court, basically at the back of your mind, you have the perception that the accused person is already guilty for some kind of offense, and therefore, since he has been doing that offense before, he should be guilty for the current offense that he is doing now. Because the current offense that he is doing now is similar or having the same modus operandi with the previous offense which he has committed. So that is one of the rationale why similar facts evidence here is generally not relevant, therefore not admissible. The second rationale for disallowing the previous misconducts of the accused person from being tendered as evidence in the court to prove the current charge is because of the fact that we have Section 5 of the Evidence Act 1950. Now, if you recall, Section 5 of the Evidence Act 1950 says that if you are tendering evidence in the court, it has to be relevant to the facts in issue and it has to be a relevant fact. So it's either one, whether it proved facts in issue or it proved relevant facts. Now, what happened here is that if you are bringing in the previous misconduct, say what happened in 2010, the incident that happened in 2010 basically happens to a different victim at a different time and at a different place. So this is basically, as a general rule, not related to the current charge, which may be happening in 2020. So in 2020, the accused person is committing a crime to one particular victim, that is perhaps V, and at one location and at one time, which is totally different from the previous misconduct that he has committed in 2010. So because of that, the incident that happened in 2010, therefore, is not totally related to the current facts in issue. So this is the second rationale why similar facts evidence shouldn't be admissible. However, when you look further into the law relating to SFE, we find that some previous misconduct can be tendered as evidence. It can be relevant and admissible in the court when the probative value of similar facts evidence outweighs the prejudicial effect of it being tendered. So in Malaysia, similar facts evidence can be tendered, and it is allowed. Basically, the relevancy of similar facts evidence have been taken in Malaysian court pursuant to Section 11, 14 and 15 of the Evidence Act. Okay? Now let's look at some illustration to reflect similar facts evidence. So what I'm saying is that when you talk about similar facts evidence, say you are talking about a situation where you have A here. So A committed assault on the victim V. This particular assault happened on the 1st of April 2020. Now what happened is that the modus operandi in which this particular accused person commits a crime is that accused person here approached the victim. So say the victim here is a 10-year-old boy. He approached this boy at Taman Tasik Shah Alam. And he approached this boy about 7 p.m. And then how he approached the boy is that he said to the boy that I have lost my cat. So there's a lost cat, and was asking the boy to help him find the cat. And eventually, when the boy asked him, he bring the boy to a secluded location and sexually assaulted him. So there has been incident of sexual assault. And after the assault, he gave this particular boy a 50-cent coin. Right. Now, this particular person now is being charged for sexually assaulting the boy, which is V. Now, the issue here, when we talk about similar facts evidence, we are trying to bring the incident of similar facts which has occurred before, committed by the accused person here at a different time, at a different place, to a different victim. As I told you earlier, when we talk about SFE, we are talking about the modus operandi, the manner in which the offense is committed. When you look at the name there, it is similar facts evidence. Yeah, you're talking about similar facts evidence. The one that is similar is the fact, that is the modus operandi, the how the offense is being committed. We are not basically talking about the character of the accused person. We are not talking about the action per se, but we are talking about the modus operandi, the how the action is being committed. So if you look at this incident, or if you look at this example here, so you have the accused person here committing the offense to victim, a 10-year-old boy with this modus operandi. And what we are going to do now is actually to try to bring the evidence of the accused person committing this crime in, say for example, on the 1st of January 2010. Yeah? The accused person on the 1st January 2010 perhaps has committed the similar offense, right? He committed the similar offense to victim 1, so V1, at Taman Tasik Titi Wangsa, right, around 7:15 p.m. And the way he approached this particular victim 1V1 here is to ask the boy here, so this particular boy may be a 9-year-old boy, ask the boy to help him search for a lost cat, and eventually he sexually assaulted this boy and give the boy a 50-cent coin. Now if you look at this incident here, okay, this particular person here has been charged for this offense, but the charge may have gone halfway, in which he may be given discharge not amounting to an acquittal, right? So he was not convicted, but he was given a discharge not amounting to an acquittal. So the issue here, when the prosecutor is charging the accused person for assault of V in 2020, can the prosecutor bring evidence of the similar incident that happened in 2010? Now, this is what we call similar facts evidence, because we are trying to bring evidence of the accused's previous misconduct, the modus operandi of the offense which he has committed in 2020, which is totally unrelated to the current facts in issue because it refers to an incident that happened at a different time, which is 2010, to a different victim at a different location. This is where, when we look at the definition or when we look at relevancy of evidence under Section 5, it goes beyond, it is outside the relevancy situation under Section 5 because we are talking about a different time, different place, different victim, right? That is why, as a general rule, similar facts evidence shouldn't be relevant and admissible. However, there will be a situation where the prosecutor can bring the previous misconduct in 2010 to the current facts issue if it satisfies the requirement of similar facts evidence. That is, the probative value of tendering the evidence here could outweigh the prejudicial effect, and it fit into the provisions which allow for similar facts evidence to be tendered, which in Malaysia may fall under Section 11, 14, and 15 of the Evidence Act. Alright, now when we look at the notes here, the relevancy of similar facts evidence can be considered under the common law, and it can also be considered under the Evidence Act 1950. Now let's look at the position of similar facts evidence under the common law. Now, to allow for similar facts evidence to be tendered under the common law, there are basically three approaches. Right? They are basically, similar facts evidence, under the common law. There are three approaches or three tests in determining relevancy of similar facts evidence. And the first case which allows for similar facts evidence to be tendered will be in the case of making using the approach of using the approach of special categorization test. And we are going to look at the second approach to similar facts evidence by looking into the striking similarity test. And the last one, the relevancy of evidence under the common law position, can be looked through the position of the Boardman test, that is the probative value in Boardman's test. So in our next video, I am going to discuss with you the position of similar facts evidence under the common law.